120 words per minute. Get ready, start. Sri Prasant Chandra, advancing his submissions, has urged that the first requirement is the intention of the members to move a no confidence motion that has to be through a written notice in the form as may be prescribed and signed by not less than one half of the total number of elected members of Jila Panchayat. The said notice has to be accompanied by the proposed motion to be delivered in person by any one of the members signing the notice to the collector of the district concerned, whereupon the collector has been enjoined with the duty to convene a meeting within 30 days from the date on which the notice under the provisions is delivered to him. The form in which the notice has to be tendered is provided for the rules referred to and extracted herein above. Sri Prasant Chandra submits that the very initiation and presentation of the notice is highly doubtful, inasmuch as the two notices which are the basis of the information to the petitioner to file this petition appear to be signed by adopting two different methods of signatures, one singular and the other in duplicate. The first notice is Annexure 3 to the writ petition addressed to the district magistrate, but the name of the district has been mentioned as Bareilly instead of Raebareli. Secondly, the said notice is undated and bears 33 names that are typed, out of whom the member mentioned at serial number 5, Geeta Giri, and the member mentioned at serial number 32, Vinay Kumar, have not signed the said notice. Single signatures are endorsed against 31 names. Thus, the notice is addressed to the district magistrate of a different district, but it does not bear any date and is not signed by two of the persons named in the notice. Consequently, the said notice was purportedly moved under the signatures of 31 members. He has then invited the attention of the court to Annexure 5 to the writ petition, which is a copy of the same notice having the same defect of mentioning the district of Raebareli and is undated, but the same contains double signatures of 33 persons, scores out one of the signatures with the addition to other names. He therefore submits that such a notice was neither in the form as prescribed. The signatures are doubtful, and not only this, according to him, 11 of the members had also denied their intention to move the no confidence motion even prior to the issuance of the impugned notice for convening the meeting. This, according to Sri Prasant Chandra, had been through affidavits that were dispatched by registered post, as the said affidavits were not received by the district magistrate. The allegation is that the affidavits were dispatched on 29/3/2017 prior to the issuance of the impugned notice. This fact has, however, been denied by the learned counsel for the state as per the record available. As would be unfolded later on, the contention of the petitioners also is that the collector on a preliminary inquiry had found himself that 4 of such members had filed their affidavits to the said effect, but the collector had erroneously not proceeded to examine the allegations that about the other 7 members. The aforesaid defects in the form, the manner of presentation of the notice, according to Sri Prasant Chandra, vitiates the notice for convening the meeting, as it is in non-compliance and in violation of 1962 rules referred to herein above. referring to Form First of the schedule appended to the 1962 rules quoted herein above, Sri Prasant Chandra submits that since the notice is addressed to the District Magistrate of Raebareli and not Raebareli, the same is not addressed to the appropriate authority, and additionally, the date not being mentioned in the notice, the computing of the period for convening the meeting not later than 30 days from the receipt of such notice would be impossible, inasmuch as if the date of the notice is not known, then the counting of the period of 30 days cannot be attempted at all. Stop.